If you have been treated unfairly in the workplace, whether that's a wage problem or whether you feel like you've been harassed, there are courses of conduct that we can take, which would include everything from perhaps a cease and desist letter, going to your human resources department to try to remedy the situation if you like your job, or it could involve filing a lawsuit against your employer. If you feel like you've been retaliated against at work, we do have some remedies. Does it ultimately result in the employee being fired? Yes, 9 times out of 10, that's the case. However, we would have some remedies beyond that in addition to filing a lawsuit. Depending on whether or not you have a union contract, we may be able to file a grievance through your union, and there may be federal or state regulatory bodies that would be interested in investigating the employer. One of the interesting tenets of Maryland law, when an employer refuses to pay wages that are due, you may be entitled to what's called treble damages or triple damages. So if an employer, for example, refuses to pay you $1,000 in wages that you can document that you have earned, if you've been fired, if you've left employment, a lot of times employers will withhold wages as a means of retaliation or a means of getting the employee to return office keys or passwords. If an employer unjustly withholds money that you have earned and we can document it, you may be entitled to triple the amount that you would normally be due, plus attorney's fees. So if you feel like you have wages which are owed to you and you have not been paid, you certainly could come to my office and we could discuss a suit. If you've been the victim of age discrimination, sexual orientation discrimination, employer retaliation, a hostile work environment, religious retaliation or religious discrimination, you absolutely could come to see me at my office and we may have a recourse for you. Pregnancy discrimination is a frequent problem. We absolutely would have a remedy to that. That is a form of sexual discrimination. Companies love to put women on leave or sort of force them out of the workplace once they become pregnant or announce that they are pregnant or once they go on maternity leave. It makes things very difficult for them. Things such as lost wages are your primary measure of damages. There may also be rare situations where punitive damages could be available. There may be situations where, in very rare circumstances, where if there's some emotional distress attached to the claim, that may be litigated as well. If someone, as a result of some sort of employer retaliation or discrimination, has to go without work for a long period of time, 6 months, 9 months, a year, those lost wage claims tend to add up significantly. If we can show that the employer did something intentionally and exercised some form of bad faith, there may be rare circumstances where punishing the employer so that they don't repeat the conduct in the future may be appropriate, and we could get a judge or a jury to award punitive damages. If you're someone who's not terribly litigious and does not automatically want to go file a lawsuit, there certainly are statutes which in Maryland and every state protect the employee. Sometimes those statutes, however, don't go far enough. So I would certainly, if necessary, contact any state or local authorities that needed to intervene, but would also at the same time on a dual track be protecting your rights and your ability to file a lawsuit if that were absolutely necessary. Do not attempt to navigate the legal system alone. Contact the law offices of John Turnbull III at 410-321-8860 to discuss your rights and how to protect them. You can also visit www.johnturnbulllaw.com.